So, good afternoon, everyone. I will be your organizer for today's event of World Intellectual Property Day. So, this is very important for we celebrate this every year by Chandigarh University and TBI on behalf of TBI Technology Business Incubator (CU). And so, this year we are again celebrating it, and we hope that from today's event you will learn a lot of things. We have a very special guest with us who will solve all your queries and doubts and give you amazing thoughts about the more deeper input about the world of business and patents and various other steps that go behind it which you might not know. So I would say that the startups world and the business world has a lot of financial and law regulations behind it, which you need to learn to run a business or run a startup. So from my side, we would like to call our special guest today, Dr. Anuj Kumar. Dr. Anuj Kumar, who is Goel, is working as an assistant professor of electronics and communication engineering in Institute of Engineering, Chandigarh University. He has teaching experience of 15 years. He has completed PhD in MS modeling from Maharishi Deemed University. He did his MTech in microelectronics and VSLI design from Kurukshetra University. He has published over 15 books uh, in his career, and emerging trends in engineering and technology. He will guide us on his with his amazing thoughts today. So it is a great input for us to learn from him today. So I will request Dr. Anuj Kumar to come and share his amazing thoughts with all us of here.
Good morning, sir. Good morning, students, all present here. Sir, can you confirm, am I audible?
Yes, sir. Anuj sir, you're very audible. You can start.
Okay, thank you. First, also confirm me that my screen is visible. Let me share it first. Sir, my screen is visible.
Yes, sir. It's looking. Yes, sir. Your screen is visible. And I will request all the students also who are attending this meeting to write in chat box if they can see the screen and the audio is clear, sir.
So, welcome you all. Very good morning to dear students of Chandigarh University. So, student, as told by Sir Banerjee, Professor Banerjee, that today is the World Intellectual Property Day. So, what is the meaning of this day and why it is made? Basically, this day means whatever ideas, whatever products, prototypes we have, we should have the right to make it a patent. Different aspects are there, different domains are there in which we can save our rights because it is your novel innovation. Okay, you should always be benefited because of your innovation. So that is why, okay, this day is made and we have many type of options by which we can get the right of our innovation. Okay, so that we will going to discuss today. So as you are all the engineering students, you are in very good domain as well. Okay, if you are from computer science and engineering, you are from specialized domains as well, artificial intelligence, machine learning, augmented reality, cloud computing, so on. So many subdomains are there in computer science and engineering. We have core branches as well, electronics, communication, electrical engineering, mechanical engineering, okay, civil engineering. So many are there. So what is the meaning of engineering? Engineering means you are you are studying the different type of technologies by which we can benefit the society, by which we can benefit our country, by which we can benefit the mankind as well. Okay. So before starting our session, okay, students, as you are the first year students, I am very happy to interact with you all because you are the fresh mind. Okay, so I want to give you few questions, not any technical question, just in general aspect that student at the time of your higher senior secondary classes, okay, what was in your mind that what you want to become in your life? And then at the first day of admission here in your Chandigarh University, what comes in your mind? At the day of graduation, graduation means when you are passing out after the 8th semester, okay, what do you think about yourself? And after completing your engineering studies, and after 5 years of that, where you are thinking of yourself? Okay, so these few answers I want from you because it's not possible to everyone to contribute. So I will ask for minimum 5 members. Okay, because these things are very must. Okay, we should much aware that why we are doing these studies. Okay, what is your goal? What is your interest? Which either you want to make a startup, or you want to become an entrepreneur, or you want to work for the multinational company, or you want to go to the defense sector, whatever is your goal of your life. Okay, that I want to know. Okay, it is just you can say sharing of ideas, sharing of thoughts. That's it. Okay, as a senior, I am here in around, I passed 16 years in teaching. Okay, in engineering education, not just teaching engineering education. Engineering education is a field where we have to be updated day by day. Okay, you are doing the artificial intelligence, machine learning, which are new technologies, which were not there 15 years back. With you as well, we are learning the technologies. Okay, so that is why we always have to be up to date. Okay, that is one point we will discuss in between. We all make it much interactive session. So moving forward for our topic of day, what is the objective? To give a general introduction to the concept of intellectual property right. Okay, because it is the day today, it is the world day today, so we should have to discuss about this. So I will take pen first. The concept of intellectual property right. Okay, what is the meaning of this? And their role in technology transfer, because we all are related to engineering domain. Okay, if we have any intellectual property right with us, so how we can do the technology transfer of that? Okay, the plan of presentation is that rationale of protection, different kinds of IPR. So it is very, very important what are different kinds of intellectual property rights are available by which you can save your idea, your innovation, your technology, your prototype, and how you can make the earning based of that. Okay, the licensing and technology agreement related to IPR. So that we will all discuss in this session. Okay. So students, we have a different type of property. We have either movable property. Okay, the example is furniture, the automobile, whatever thing which is the movable. We have the immovable property, that is land, building, infrastructure. And then we have the intellectual property. Okay, so these are basically These properties, first two properties, movable and immovable, these are called the tensile property. Okay. While the intellectual property comes under the intensile property. Okay. Intensile property means where we have some idea, where we have some innovation, by which we can benefit the society, by which we can make the environment much better. Okay. So it is the creation of human mind, which is the very important. Okay. It is basically the intellect. Okay. Creation of human mind, innovation of human mind. What comes in your mind with your education, as we are doing the project as well? If you have any innovative idea that is not done before, okay, so for that you can make a patent of that. If you have any special type of logo or some symbol you designed for your company, so for that you can make the trademarks. Okay, if you have a special quotation that is new to this environment, that is new to the technology or industry, so for that you can make the copyright. Furthermore, many other options are available to make the intellectual property right. Okay, so that all I will explain to you. Exclusive rights given by the statute means what are the different rights given by the government. Okay, if you have the patent with you, so many rights are given to you by the government as well. If you have the patent, so no one can use your technology. Okay, if you have the patent of some process, that by this process you can make this type of device, so that process no other person can copy. If some company, some industry want to adopt your process, then that industry should take permission from yourself. Okay, they will pay a good amount of money to you. You can get the royalty, whatever things. These all will be decided by you. But the main thing is that you should have the IPR with you. Okay, different forms are here. So briefly, I will explain them here. Attended with limitations and exceptions. So limitations and exceptions are there because the technology can't be complete. Okay, technology is day by day changing. So when someone have the other model, so that can be applied for the patent. Time bound, these IPRs are time bounded. Okay, no IPR is for the lifetime. Okay, either it is 5 years, 10 years, 15 years, 20 years. Every IPR is time bound. After a time, you can also extend your IPR. It all depends on you. Okay, but initially it is time bound. Territorial, what is the meaning of territorial? It means if you are filing the patent in India, okay, it is limited to our country only. If you are making a technology on Internet of Things, okay, you are making any, I will say any agriculture application using the Internet of Things, using cloud computing. So that patent, if you are applying here in our country, in India, so that is limited here for India only. Okay, you can't force the people in Australia that you can't use my technology. No. If you want to make it to the international level, so you have to apply for patent in that country as well. Okay, so it is the territorial. So that is written territorial means if you are applying here in India, so your patent will be valid in India only. Okay, if you are applying for patent in Australia, so your patent will be valid in Australia only. If you are applying in USA, Europe, so on so it is territorial based. Okay, patents are territorial, not the patent, the IPRs. Okay, intellectual property. These are territorial. Time bound, the time limit is fixed in every type of IPR. Now, what is the basic definition of this? Intellectual property shall include the rights relating to literary, artistic, scientific works, performance of performing artists, phonograms, broadcast, inventions in all fields of human endeavor, scientific discoveries, very, very important, industrial design, very important, trademarks, service marks, and commercial names and designations, protection against unfair competition, and all other rights resulting from intellectual activity in the industrial, scientific, literary, or artistic field. These all comes under the intellectual property rights. Different forms are available that I will explain you. With that different form, either you can go for the patent, either you can go for the copyright, you can go for the trademark, you can go for the industrial design, you can go for the geographical property. So different forms are available in which your idea comes. So that we have to find out. So different international treaties are there to make it applicable. Okay, first it started in Paris. Paris Convention for the Protection of Industrial Property. It was made in 1883. So you can see when the Industrial Revolution started. Okay, from that time we have the protection of the industrial property. Okay, so it started in 1883 from Paris Convention. Then in Berne Convention for the protection of literary and artistic work, it was in 1886. Then we have the International Union for New Varieties of Plants, that was in 1961, 72, 78, 91. Okay, so time by time they have the updations as well, that these things should be added to improve it. Convention on Biodiversity. Okay, we comes to the bioengineering in 1919. So it was documented in 1992. Convention on Biodiversity to make the bioengineering biodevices under this category. Okay, the IPR started for bioengineering in the 1992. Agreement on trade related aspects of intellectual property rights in 1994. Then Internet treaties also come in 1996. So these are different international treaties, means agreements to make the IPR. So you can see first we have the Industrial Revolution, then they add the literary and artistic works, then they add the different plant formations, then biodiversity is added. Okay, then we have the Internet treaties as well. So what is the basic principle? There is the contract between creator and sovereign state, protection for revelation. Okay, so if you are the creator, if you made any technology, so you can protect it, that it is my technology. Okay, then if some industry, some other people want to work over that technology, so they should take permission from you. It is the best use of the IPR. Balance between rights of creator and public interest. Okay, rights and limitations and exceptions. So limitations are always there because the technology should be transferred. If you are making anything, if you have any good innovative idea, you prove that, you make the prototype of that, you justified that yes, it is a new innovative technology. After that, you are not making any product, you are not interested to make anything. Okay, other people want to create it for the benefit of society. So you can't force them up to a certain time that you are not making any product of that, because it is a technology, it is innovative technology, it is used for society, you already proved that. Okay, but after that, it is also a limitation that you have to make it marketable as well. Okay, so you have the right as well as limitations are always there, because technology is always for the mankind. Now it is the very important part. Okay, so what are the major intellectual properties, okay, by which we can apply? So the first major one is the copyright and related rights. So copyright, okay, that is the first one. Then we have the different industrial property, as we leading one is the patent. Okay, maximum of you must be known about this term patent. Then we have the industrial design. Trademarks. Marks means if you have any geographical mark, any not geographical, the graphical mark. Okay, then geographical indications, layout, topography of integrated circuits. This term may be new to you, integrated circuits. So in your higher classes, when you upgrade your knowledge, then you will come to know these are basically electronic circuits, electronic ICs. Okay, whatever electronic gadget we are using, either you are using the laptop, you are using the mobile phone, day-to-day life have many of the electronic gadgets. So in build of them have the integrated circuit. It is a black body object. Okay, in IC we have the many logics by which device works. Okay, then we have the trade secret. Trade secrets means if any idea doesn't come under this category. Okay, you can't make the patent of that, you can't make the industrial design, you can't make the trademark. So that comes under the category of trade secret. Okay, these are few, you can say secrets, okay, which can't be made public. So these comes under the category of trade secret. Then protection of new plant varieties. Okay, these are different ways by which we can make the intellectual property right. Okay, basically intellectual property. These are different ways. So on them, we will try to discuss as much as possible. So in Indian government, what are different laws for the IPR? Okay, we have the Copyright Act 1957, that is under the Higher Education Ministry. The Patents Act 1970 under the Industrial Policy and Promotion. The Designs Act 2000 under Industrial Policy and Promotion. The Trademarks Act, again industrial. Geographical indications, industrial. Semiconductor ICs under information technology. It also covers the electronics industry as well. The production of plant varieties and farmers under the Agriculture and Cooperation Ministry. Okay, so in the previous slide, I had told you different domains in which we can make the IPR. Okay, and these all are protected by the Indian government as well. We have the exact regulations. Okay, if you have the IPR, so no one can challenge you. Okay, so it is the, if you are the engineer, you are in the engineering domain, so you should have knowledge of this type of protections which are given by the government of India as well. Okay. Okay. So after basic, now one by one we will cover these topics. What are these IPR? So first we have the copyright and related rights. So what comes under this category? Okay, original, literary, dramatic, musical, artistic works. Okay, it works for the ideas expressed in material form. And it also covers the cinematographic sound recording. Okay, these all things you can make the copyright of that. All the movies, okay, that we watch, either Bollywood, Hollywood. So all the movies are also copyright protected. Okay. The rights, two kind of rights are there. We have the moral rights and we have the economic rights as well. So economic rights are very, very important, as we all know. What are the moral rights? Right of authorship and the right of integrity. Okay, under this we have the digital manipulation and no right for display. Okay, if you have some video clipping, some feature you have, okay, no one have the right to display for that without your permission. We have the inalienable rights as well. So the most important part, economic rights. If you have the copyright, so what economic rights you have? Right of reproduction. Okay, making copies of an edition of a novel. So if your novel is very much popular, no one have the right to copy it. Okay, only you are the person who have the copyright of that. Only you can authorize one person, one press to make a copies of your novel. Okay, complete rights of yours. Then storage in computer memory. No one can store your data in the digital form as well. That is completely protected. Right of distribution and issue of copies. Either it is digital or physical distribution. Right of communication to the public. Okay, public performance, internet communication. So every benefit is given to, just you have the copyright of that. Adaptation rights, conversion into another form, that is literary to drama. For example, you have one novel, okay, and someone want to make a drama over that. Someone want to make a movie over that. So that person can't make. Okay, that person have to take permission from you. That comes under the copyright economic rights. You have the right. Okay, if someone doing it without your knowledge, okay, so you can go to the court, because government of India gives us right that you can have the option that no one can use your thing. Okay, so these all benefits of the this particular copyright. Now we have the ownership of right. Okay, for literary authors, for drama, music, for music composer have the ownership. Okay, so these are the people who have different rights. For artistic work, the artists have the ownership right. The photographer for the photographs. No one can also publish your photograph without your permission. If you have the computer program, I think it is much important to you. Okay, if you have any good program that is used for one application that is not made till now, so that is protected. Okay, if you have the IPR over that, if you have the copyright of that, so no one person can use your program. Okay, sound recording, for that producer have the ownership right. Okay, so this all detail for the different type of authorship and system. So in order to secure the copyright, okay, so formality-free protection is there. We can go for the registration as well. Duration of copyright for literary, drama, music, and artistic work. Okay, during lifetime of author. So after that life, more than 60 years, okay, that thing is protected with the name of that author, or dramatist, or the musician, or the artist, whatever is there. All other works 60 years from the date of publication. Only these works. Okay, if you have some novel, if you have the drama, if you have the music, okay, if you have some play as the artist, so that is also protected after your life. After your life, it is protected for more 60 years. Okay, but for all other works, it is for the 60 year from date of publication. If today you make the copyright, so you have that right up to the 2082 or 81, whatever it is. Okay, so it is the time limit of the copyright. So different rights are there for the performers. The duration is 50 years. Okay, for broadcaster it is 25 years. Okay, so it is about the copyright. Which things you can make the copyright and what benefits you will get of that copyright. Now the most important thing for the technical people, okay, for engineers is the patent. So what is a patent? Okay, a patent is an exclusive right granted for an invention, very important, which is a product, okay, it is a product or a process that provides a new way of doing something or offers a new technical solution to a problem. Okay, if you have any prototype of any innovation, so for that you can apply for patent, or even if you have the process by which you can make a technology. So for both the things we can go for the patent. The limited monopoly right granted by a state enables an inventor to prohibit another person from manufacturing, using, or selling the patent product, or from using the patent process without permission. Okay, so if you have the patent of your prototype, if you have patent of your process, so no one can do the manufacturing of that, no one can use in other application, and no one can sell your idea without your permission. Okay, so what things we can be make a patent? Inventions in all fields of technology, okay, whether product or process, that should meet this criteria. That is very much important. First is the novelty. Okay, it should be new. Your idea should not be in the market. Market means you can search from internet, you can search from different industries. Either this idea is available or not. So novelty is there. Okay. Then non-obviousness and industrial application should be there. Utility should be there. For which application it is made. What is the utility of this? So that thing should be there in a patent. We should have the novelty. Okay, it should not be non-obvious. It is for the industrial application. Utility should be there. What is the meaning of novelty? Invention not known to public, prior to claim by inventor. Okay, it should be new to everyone. So different stages are there for the patent. I will explain you that as well. Inventive step. Invention would not be obvious to a person with ordinary skill in the art. It should not be a ordinary skill. Okay, so ordinary skill can't be a patent. Industrial application. Invention can be made or used in any useful practical activity as distinct from purely intellectual or aesthetic one. Okay, your your prototype should have the industrial application. Okay, so these things, three things should have in the your idea. Now, grant of patent. Okay, patents are granted by National Patent Office after publication. Okay, so now different terms are there. Okay, first term is the registration. So I will see the option to right here. Okay, so first option is the registration. We have to make the registration of that. So after making a registration, we will get the application number. Okay, when you applied for the patent, you have to make the certain type of document. Then you can make the go for the registration. Then you will get the application number. Okay, then your patent, your application will be published. Okay, your next stage is the publication. That is written here, publication. Okay, it is made for 1 year of time. Within 1 year, you have to present yourself in front of the evaluation committee. You have to show your prototype. Okay, you have to justify the innovation, you have to justify the non-obviousness, you have to justify the industrial application. If you are able to justify these three things, then you will get the patent. Your patent will be granted to you. Okay, so the grant of patent is the last stage. Before that, we have to register for the patent. For that, you will get the application number. Then your patent will be published. When our patent is published, then we have the pre-grant and post-grant opposition by the other people. Okay, the people can make the opposition to you that this technology is already available or that person have the technology already made. Okay, so after the publication, that particular document is online. Anyone can refer that document. You can see that document and you can find out that this technology is my or it is already existing. If it is already existing, so you can make the opposition of that. Then at the same time, that patent application is rejected. Okay. So in our country, we have the different patent offices where we have to go for the to defend our patent, defend our application. Okay, we have offices in the Delhi, Mumbai, Kolkata, Ahmedabad, Chennai. Okay, which innovations, inventions can't be go to the patent level. Okay, so it covers any invention which is frivolous, which claims anything obviously. Okay, for example, Newton's law of gravitation. So this law is already proved by Newton. Gravity is always there. Okay, you can't apply for patent for that type of obvious laws which are already there or which are already existing. Okay, you can't go for a machine whose primary or intended use, commercial exploitation, okay, morality. For example, gambling machine, okay, device for house breaking, biological warfare weapon material. Okay, so these type of things which are not good for society. Okay, for that you can't go for the patent application. Mere discovery of a scientific principle, formulation of an abstract theory, okay, discovery of any living thing, non-living substance, that we can't go for the patent. Okay, the mere discovery of a new form of a non-substance which does not result in enhancement of the non-efficiency of the substance, new use of a non-substance, so these also can't go for a patent. Okay, so I told you these things can be go for the patent and what things you have to justify for the patent. Okay, you have to justify the novelty, you have to justify that it is non obvious, and you have to justify the industrial application. Okay, so two IPR things we have discussed so far. First is the copyright. Okay, uh, that we discussed in detail what comes under the copyright. Then we have the patent. Okay, so we have around 15 minutes. Now, students, I had given you one task. Is there any way so I will stop share. Right now, 285 members are present. Sir, is there any raise hand or any? Yes, students. Initially, I asked you that
Sir,
when
we
you are
can
in.
there is a we can do a short Q&A. You can ask the students to ask you some questions if they have any doubts or not, and they can write in the all the students if you have any doubts or want to ask any questions, you can just write in the chat box, and sir will be happy to answer them.
Instead of that as well, students, initially I asked you a few things that when you are in your 12th classes, what was in your mind, what you want to become in your life, and when you got admission in engineering, what was in your mind? Okay, when you come to the graduation day, the final day of your passing out, so at that time, what you are thinking? What was your stage, and when you pass 5 years of your studies, then what do you think? What target, what goal you will achieve in your life? So you can put in the chat box. So I will ask sir to, so you can share. Yes, one question is there by one student for the territorial issues. Students, if you have patent here in India, so it is valid for India only. Okay, so the other country can use that technology. If you want to protect in that country as well, so you have to file your patent in that country as well. Yes, student, it is possible. The territorial limitations are there. Okay, that
Sir,
is fine.
there is one more question that our student is asking, that how has you seen the change of that patent process filing being from offline to online? Previously, it was more of a lot of papers, a lot of more economically tiring. Now it is very easy to file a patent and copyright. So what's your take on that? A student is asking.
Yes, students, we can go for the online mode. Okay, but in order to define our patent, then you have to give the prototype. When you have to come in front of the evaluation committee, then physically we have to go there and justify our work. Only then final patent will be granted. But we can initially apply online. It is online process. Online we have to apply. The your application will be published as well. Okay, so now for 5 minutes I will make one website to you. So instead of this presentation, So students, sir, my screen is visible.
Yeah, yes, sir, it is visible.
Yeah, students. So just for your knowledge, okay, because only the slide presentation is not give the enough information to you. Okay, we now you have general idea that you can go for different type of intellectual property rights. Okay, different categories are there. So you have to find out in which category you come from. Okay, now I want to show you what is the website. It is the website of Government of India, okay, in which you can apply. So instead of apply as well, if you want to make your mindset that which ideas are there, so you can also search for that as well. Okay, it is the main website. You have the option of patents that I told you. We have the option of designs. We have the option of trademarks. Okay, so different options are there in which you can apply for the copyright. Okay, so be in touch of these websites. So students, just for your knowledge, as you are asking how to search for different patents. So a method of adapting the procedure for this particular medical term. Okay, the application number is this one 1432 oblique so and so. It was in the year 2010 and it was granted in 2016. Okay, and it is the patent number. When finally you get the patent, okay, so you will get the patent number of that. So in this form, you have the legal document which will pass by the government of India. You will receive that document and you can keep that type of document with you. So it is a list of different patents. Okay, it is a long list. These all related to the medical side for biotechnology. Okay, so in this way, how we have to search. So you can search out for different domains and then you can find out that this technology is existing or not. Okay, so if we are looking for the designs, okay, so that I told you, first you have to apply for the IPR, whatever it is, either it is a trademark or it is a copyright or it is a patent or it is the industrial design. You will get an application number of that and after a time it will be published. Okay, so these are the different outcomes of this. It is the journal in which different patents are published. Okay, it is the second stage. So it is with the name of Success Guru Arun Kumar Mishra. Okay, it is made by A.K. Mishra and it is the purpose to be used whatever things shared by you in the application, so that all will be published. Okay, these are the published applications. You can see trade markers, journal number is 2049. It was published in 25th April. So it is very latest. Just yesterday, this journal is published. And these all are the inventors who applied. Okay, it is the application number and it is the date. Okay, so I am just explaining you these things so you will become familiar about these things. Okay, how to search for that, what other people are doing. If you are seeing that how many people are working in this field, which type of products they made, so that will also enhance your knowledge. That will also create your interest as well. Okay, So that is the way, students, how you can find out differently. Now I think somewhat interest is created, or if you have any doubt, any specific doubt, so you can ask. I am very much happy to answer your queries, because these sessions are just made so you can create your interest. Okay, if you are not uh, feeling happy, so it doesn't mean anything to create this type of event. Yes, if you have any doubts, so I'm very much happy to answer you. So just uh, within your 4 minutes, I will explain you briefly what are different stages we have. We discussed about copyright. Second is patent. Okay, then we have the industrial design. So these are the examples of industrial design, different type of design. These are the protected with IPR. Okay, no one can copy the same design. Pharmaceutical product, how the medicines are preserved. Okay, so these all are protected. You can't copy the design of any other company. Textile and jewelry, every design is protected. Okay, so these are the example of the industrial design. Then we have the trademarks. So these are the trademarks, the Coca-Cola written, the Godrej written, the GE written, how you are writing your company logo, how you are making it public, okay, how you advertise your product. So these all are protected. So these are different forms of trademark. Then we have the geographical indication. For example, the example here is, for example, we have the rice. Okay, specific rice categories we have. Okay, specific categories of fruits we have. So that name can't be copied. Then we have the IPR related to industrial revolution, that is related to integrated circuits as well. The different layout designs are also protected and its validity is up to 10 years. Then we have the trade secrets. These are the, we can say IPRs, which doesn't come under the normal category. Okay, these are some inventions, data, information, which cannot be protected by other IPRs. These are actually confidential, okay, which comes under the category of trade secrets. Okay, then last we have the plant varieties and farmers' rights, how they are making their farming. Then we have the international organizations which are working for the IPR rights. So World Intellectual Property Organization we have, then we have the World Trade Organization who are prevented for the IPR worldwide. We have the IPR licensing and technology transfer agencies and rule regulations are. Okay, so your IPR is protected all over the world. So your idea should be novel and innovative. Okay, so thank you everyone. Thanks for giving your time and listening here. So this session is for different type of IPR rights. Okay, we have. Thank you, students. Thank you. If you have any query, please.
Thank you, sir.
Thank you, sir.
Thank you, sir, from our side. You made it a lot simpler for all the students to understand. I think they have gained a lot of interest into this subject, and they will keenly take more interest and search more about this. So again, a lot of thank you from our department. Thank you for being with us. We hope you will be with us in more future sessions to come regarding this topic. Thank you, sir.
Okay, thank you. Thank you, students. Be in touch with all the websites that are available online. Okay, search for the latest patents, technologies. So that will definitely create your interest. Okay, and I'm happy to see that a few students are giving the good response here. Okay, so this session is made for your knowledge, just to create your interest in this field. Okay, so all the very best to you for your studies. Thank you. Thank you, everyone. Thank you very much.
Thank you, everyone. Now we are ending the session. Students, thank you for all for a patient hearing.
Sir, just wait for a while. Students, do complete your feedback form. On the basis of that, you will get your attendance. So you all need to fill that. Feedback link I have already shared in this chat box. Just scroll above. That is mandatory for everyone to fill. Just wait.
Ma'am, you could please again share it so the students can.
Yes, sir. Yes, sir. Just wait. I have shared it again, and we'll share it with your mentors also so that you can complete it. Okay, thank you, sir.
Thank you, ma'am. Okay, students. So we are ending the session right now. Have a good day.